What is the status of the following marriages? A marriage between a step-brother and a step-sister. It will depend on the date of celebration of marriage. If the marriage was celebrated during the effectivity of the Civil Code but prior to the effectivity of the Family Code, said marriage is expressly prohibited, therefore, void. However, if the marriage was celebrated from the time the Family Code took effect, or on or after August 3, 1988, said marriage is no longer prohibited. A marriage between a half-brother and a half-sister. Void for being incestuous. Marriages between brothers and sisters, whether of the full or half-blood, are incestuous and void from the beginning, whether relationship between the parties be legitimate or illegitimate. A marriage which took place 5 months after the issuance of a marriage license. Void for absence of an essential requisite. A marriage license shall be valid in any part of the Philippines for a period of 120 days from the date of issue, and shall be deemed automatically cancelled at the expiration of the said period if the contracting parties have not made use of it. A marriage contracted by an 18-year-old illegitimate child who obtained the parental consent only of her putative father. Voidable for lack of parental consent. Since illegitimate children are under the exclusive parental authority of their mother, it is the consent of the mother that is required.
A second marriage celebrated on August 3, 1984 contracted by a person whose first husband had been missing for 4 consecutive years, without securing a judicial declaration of presumptive death. Valid. The requirement of securing a judicial declaration of presumptive death for purposes of remarriage applies only to marriages celebrated during the effectivity of the family which took effect on August 3, 1988. Prior thereto, the applicable law is the Civil Code which does not impose a similar requirement.
A marriage where one party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable during the marriage. Valid. For affliction with a sexually transmissible disease, STD, to render a marriage voidable, it must either be a. existing at the time of the marriage, or b. concealed and existing at the time of the marriage amounting to fraud in obtaining consent. A marriage which took place with the presence of only 3 persons, the contracting parties and the solemnizing officer. Valid. The absence of at least 2 witnesses of legal age is a mere irregularity that shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally and administratively liable.
What are the instances when marriage license may be dispensed with? Marriage in articulo mortis, at the point of death, even if the ailing party subsequently survives. If the residence of either party is so located that there is no means of transportation to enable such party to personally appear before the local civil registrar. Marriage among Muslims or among members of the ethnic cultural communities, provided they are solemnized in accordance with their customs, rites or practices. Marriage between a man and a woman who have lived together as husband and wife for at least 5 years and without impediment to marry each other. Marriage is celebrated abroad and in accordance with the laws of the place of celebration which do not require a valid marriage license. Bonus can consul generals, consuls, or vice-consuls solemnize a marriage abroad between a Filipino and an alien. No, consul generals, consults, or vice-consuls cannot solemnize mixed marriages. Only marriages between Filipino citizens abroad may be solemnized by a consul general, consul or vice-consul of the Republic of the Philippines. With this, their authority is limited to marriages of both Filipinos residing abroad. When is declaration of nullity of marriage on the ground of psychological incapacity warranted? Gravity. It must be grave and serious such that the party would be incapable of carrying out the ordinary duties required in a marriage. Juridical antecedents. It must be rooted in the history of the party antedating the marriage, although the overt manifestations may emerge only after the marriage, and incurability. It must be incurable, or even if it were otherwise, the cure would be beyond the means of the party involved.
What are the properties included and excluded in the absolute community of property? Properties acquired prior to the marriage. General rule. Included in the absolute community of property. Exceptions. A. Those excluded in the marriage settlement. B. Those for personal and exclusive use, and C. Those acquired by either spouse who has legitimate descendants by a former marriage, including fruits and income. Properties acquired during the marriage.
General rule. Included in the absolute community property. Exceptions. A. Those acquired through gratuitous title, including fruits and income unless expressly provided by the grantor that they shall form part of the absolute community property, and B. Those for personal and exclusive use.
What are the properties included and excluded in the conjugal partnership of gains?
Properties acquired prior to the marriage.
General rule. Not included in the conjugal partnership of gains, but fruits and income accruing during the marriage are included.
Exceptions. When included in the marriage settlement subject to the following limitations: A. May not exceed more than 1/5 of present property, and B. May not include properties acquired prior to marriage if either of the future spouses has legitimate descendants in a former marriage.
Properties acquired during the marriage. General rule. Included in the conjugal partnership of gains. Exceptions. A. If acquired through gratuitous title, but the fruits and income of said properties are included in the conjugal partnership of gains. B. If acquired through onerous title and, using exclusive money or funds, or using conjugal funds but the acquisition is by way of right of redemption, subject to reimbursement. When may a child conceived through artificial insemination be considered legitimate? 1. The artificial insemination is made on the wife, not on another woman. 2. The artificial insemination on the wife is done with the sperm of the husband or of a donor, or both the husband and a donor. 3. The artificial insemination has been authorized or ratified by the spouse on a written instrument executed and signed by them before the birth of the child, and 4. The written instrument is recorded in the civil registry together with the birth certificate of the child, who may adopt under RA number 8552.
1. Any Filipino citizen, A. Of legal age, B. In possession of full civil capacity and legal rights, C. Of good moral character, D. Has not been convicted of any crime involving moral turpitude, E. Emotionally and psychologically capable of caring for children, F. At least 16 years older than the adoptee, and G. Who is in a position to support and care for his children in keeping with the means of the family, or any alien possessing the same qualifications as above stated for Filipino nationals, provided, A. His country has diplomatic relations with the Republic of the Philippines, B. He has been living in the Philippines for at least three continuous years prior to the filing of the application for adoption and maintains such residence until the adoption decree is entered, C. He has been certified by his diplomatic or consular office or any appropriate government agency that he has the legal capacity to adopt in his country, and D. His government allows the adoptee to enter his country as his adopted child.
3. The guardian with respect to the ward after the termination of the guardianship and clearance of his financial accountabilities.
When may the 16-year-old age gap between the adopter and the adoptee be dispensed with?
1. The adopter is the biological parent of the adoptee, or 2. The adopter is the spouse of the adoptee's parent. Who may be adopted?
1. Any person below 18 years of age who has been administratively or judicially declared available for adoption.
2. The legitimate son, daughter of one spouse by the other spouse. 3. An illegitimate son, daughter by a qualified adopter to improve his/her status to that of legitimacy. 4. A person of legal age if, prior to the adoption, said person has been consistently considered and treated by the adopter as his/her own child since minority. 5. A child whose adoption has been previously rescinded, or 6. A child whose biological or adoptive parent has died, provided that no proceeding shall be initiated within 6 months from the time of death of said parent.
What are the exceptions to the rule that husband and wife must jointly adopt? 1. If one spouse seeks to adopt the legitimate son, daughter of the other. 2. If one spouse seeks to adopt his/her own illegitimate son, daughter, provided, however, that the other spouse has signified his/her consent thereto, or 3. If the spouses are legally separated from each other.